Hello, everyone, and welcome to the June edition of Miller Johnson's Benefits Lunch Break webinar series. My name is Brett Liefbroer, and I am a senior counsel in Miller Johnson's Employee Benefits Practice Group. And I will be taking us through today trending topics in health and welfare benefits that may be impacting employers and their employees and plan participants in 2025 and beyond. So a few housekeeping items before we get started. This year we are doing our webinar series on a quarterly basis. Of course, this is our June meeting for the second quarter of 2025. Earlier this year, my colleague Nate Caberly covered updates for retirement plans, including Secure 2.0 changes. Today, I'll be talking about health and welfare benefit changes. And we do not have a topic announced yet for our August 20th webinar. If there's any topics out there that people are interested in hearing about, please do let us know. We are far enough in advance of that August meeting that we can address a topic that seems to be a popular one among our participants. And for our December 17th webinar, it's typically popular for us to do a Ask a Benefits Attorney style webinar, where you get everyone from our employee benefits practice group, and we'll usually have a guest from our labor and employment practice group as well. And we'll take questions in advance of that December webinar, and we'll address all of those questions and move through them and answer them. And if there's any live questions that come in, we also will address those. So without further ado, I'll be talking today about what are some of the trending health and welfare benefit topics in 2025 and anything in 2024 that we need to know about as well that is starting to take effect this year. I do plan to provide updates across all three branches of federal government today. So we'll visit the legislative branch and see what they've been up to, including proposed legislation, including the One Big Beautiful Bill. I'll talk about that and what may be on the horizon related to that bill. And we'll also talk about, there have been a lot of new waves of litigation. So we'll visit the judicial branch as well and talk about what some of the newer waves of litigation are and what employers need to watch out for this year on that front. And finally, we'll visit the executive branch and I'll give a regulatory update. We'll cover a few of the Trump administration's executive orders that are related to employee benefits, as well as some of the more standard regulatory updates from the different sub-regulatory agencies, so the Department of Labor and the IRS, and we'll provide any necessary updates there. So starting with a legislative update. In terms of enacted legislation, it's been relatively quiet for the first half of 2025. In fact, the two most significant pieces of legislation that have made it through Congress and been signed into law were actually signed into law at the end of the Biden administration, as you can see here on December 23rd, 2024. And the first of those two pieces of legislation is the Paperwork Burden Reduction Act. So under the PBRA, applicable large employers, which would be any employer with 50 or more full-time employees or full-time employee equivalents under the Affordable Care Act, those ALEs generally are no longer required to furnish Forms 1095-C to all of their full-time employees, except upon the employee's request. So this is some relief for many of our ALEs, but this relief is not automatic. As brief background as to why this law came into being, under the ACA, employers originally were required to report the health coverage provided to their employees, both to the IRS as well as to the employee. Although the ACA individual mandate penalty has now been reduced to zero, employers were still required to report the health coverage information to their full-time employees. And relevant to this new law, the ACA pay or play penalty, which is applicable to employers rather than employees, remained in place, and that penalty was not reduced to zero. So that pay or play penalty still applies to ALEs that fail to provide qualifying health coverage. And a failure to provide qualifying health coverage may result in an ALE receiving an IRS letter 226J with the proposed penalty. An employer will know if they have received one of these letters, because the penalties can be quite substantial. And oftentimes, what the IRS will do is assert these penalties quite heavily up front, and then switch the burden to the employer to then prove the IRS wrong and to prove that the employer is not subject to that pay or play penalty. So the IRS oftentimes will look at the number of forms W-2 that an employer has filed for a particular year, and just multiply this ACA pay or play penalty by the number of forms W-2 filed. And the amounts of penalties can very quickly reach $50,000, $100,000 or higher, and add up very quickly. So this pay or play penalty is still a significant issue today. So under the PBRA, ALEs are now only required to prepare the forms 1095-C, file them with the IRS, and provide employees with a clear, conspicuous, and accessible notice of the employee's ability to request the forms 1095-C. So the employers are not necessarily off the hook from having to prepare these forms 1095-C. So the time commitment may still be the same with respect to preparing these forms and preparing them accurately. But now there's still a lot of employers out there that are mailing out these forms 1095-C every year to all of its full-time employees. This new legislation is intended to provide a little relief from that mailing requirement. So what is considered clear, conspicuous, and accessible notice? So the statement must be posted clearly and conspicuously on the ALE's website. And the statement must contain an email address, a physical address, and a telephone number that employees may use to contact the employer or the employer's contact if they have questions about how to receive copies of their forms. That statement of availability must remain accessible until October 15th of the year following the applicable calendar year. So for 2024, this notice of availability would need to remain on the ALE's website until October 15th, 2025, in order to satisfy this notice requirement. Before switching from automatically sending a copy of Form 1095-C to employees, employers need to provide proper notice to employees informing them of their right to request a copy of the Form 1095-C. And if the employee requests a copy of that form, the employer may still avoid sending a paper copy if the individual has previously consented to an electronic delivery method and that employee has not affirmatively opted out. If an employee does ask for a copy of their form, the employer must provide a copy of that form by the later of 30 days of the employee's request, or by January 31st of the year following the applicable calendar year. A second related piece of legislation providing relief on the ACA reporting front is the Employer Reporting Improvement Act. So under the ERIA, employers are permitted to electronically deliver Forms 1095-C. In order for employers to electronically deliver this form, the employee must have previously affirmatively consented to electronic delivery, and the employee must not have revoked that consent. This is also a law that was passed at the end of the Biden administration in December last year. This law took effect immediately for the 2024 calendar year, meaning that if employers were aware that these laws had been passed in time for the applicable deadlines for furnishing these forms to individuals, which would have been early 2025, employers could take advantage of these electronic delivery methods and substitute notice requirements for employees. Notably, under the ERIA, this law created a 6-year statute of limitations that applies to the IRS assessing and collecting ACA pay-or-play penalties. Previously, the IRS had explicitly taken the position that no statute of limitations applied to the collection of these ACA pay-or-play penalties. So even if an employer had been filing its forms 1095-C since the inception of the reporting requirement, which would have been back to 2015, the IRS could levy a penalty, in later years, up to and including today, for 5, if not 10 years ago, imposing penalties, which obviously was a burden on employers. And even with the 6-year statute of limitations, the IRS still, one of these letters 226J may show up many years after the reporting has been completed for a particular year. Welcome news to employers under this ERIA is employers now have at least 90 days instead of the previous 30 days to respond to any letter from the IRS imposing or assessing these penalties. Oftentimes between the mailing time from the date of an IRS notice to the time that that notice reaches a decision maker at the employer who can do something about that notice and respond to it, sometimes that doesn't even happen within the first 30 days. So this is certainly welcome news for employers to now have 90 days to respond to these IRS penalty letters. Finally, employers may now use dates of birth as a substitute for an individual's social security number under certain circumstances. Those circumstances would be if an employer on multiple occasions has asked an employee for their social security number and the employee has continuously refused to provide that. Employers may now use an employee's date of birth on that Form 1095-C. So in terms of proposed legislation, the big one on the horizon is the one big beautiful bill. The BBB passed the House on May 22nd, 2025. And in order to become law, it needs to still pass the Senate and be signed into law by the president. And this past Monday, so June 16th, the Senate Finance Committee released a draft version of the Senate's version, essentially, of the BBB and what they think it might look like. So in the House bill, There were a whole host of changes designed to increase the flexibility of health savings accounts and health reimbursement arrangements. In the Senate version of the BBB, all of those HSA provisions and HRA provisions designed to make those arrangements more flexible, those have been stripped out of the Senate version of the bill. Of course, there is still a lot of negotiation that needs to go on between the House and the Senate before this bill becomes law. So it's possible that those flexibility provisions may come back. But as of right now, they've been taken out of the Senate version. Some items that still remain in that bill are a provision that makes permanent a tuition and student loan reimbursement temporary provision that allowed employers to reimburse student loans on a tax-free basis up to $5,250 per year under Section 127 of the Internal Revenue Code. That was a provision that was scheduled to sunset at the end of 2025 in the House and the Senate versions of the BBB. That provision is made permanent, so it's likely that that one will survive. There also are some provisions that remained in the Senate bill that were in the House bill related to qualified transportation fringe benefits, which may be relevant for employers out there, paying for employees parking or commuting, or transportation from a distant parking lot to the employer's business site. There's tax credit changes that are still out there, notably related to the child care credit and the child tax credit, increasing the amount of that child care tax credit, and also credits out there for employers for paid family and medical leave. So we need to stay tuned on the BBB to see which benefit provisions make it through. So in terms of enacted legislation, I mentioned that it's been relatively quiet on the health and welfare front for the first half of 2025. On the horizon, there's widespread bipartisan support for increasing pharmacy benefit manager transparency. State legislatures have also gotten on the bandwagon of regulating pharmacy benefit managers, all in an attempt to rein in the costs of prescription drugs. Telehealth, the temporary relief that allowed telehealth to be provided without jeopardizing individuals' health savings account eligibility. That temporary relief has expired, so we will need to see future legislation to avoid adverse tax consequences from employers providing telehealth services or providing telehealth options to their employees. The Trump administration is focused on increasing transparency related to prescription drug pricing. And in terms of the Affordable Care Act, during the first Trump administration, there was an attempt to repeal and replace the ACA. We don't expect to see a full repeal and replace attack on the ACA, but certainly the Trump administration may be focused on making changes to the ACA, perhaps to remove some of the teeth from that law. So moving on to a litigation update and the judicial branch. Perhaps the most important case out there right now at the U.S. Supreme Court is Braidwood Management v. Becerra, now currently known as Kennedy versus Braidwood Management, just based on the Secretary of Health and Human Services. This is a suit targeting the ACA mandate, making certain preventive care free or providable without any participant cost sharing. Under current law and regulations, any preventive care receiving an A or B recommendation from the United States Preventive Services Task Force on or after March 10th, 2013 has to be provided without participant cost sharing. At the district court level, a district court found that the USPSTF the members of that group were not properly appointed in violation of the Appointments Clause of the US Constitution. And as a result, any of those A or B recommendations did not have to be covered without participant cost sharing. The Fifth Circuit on appeal partially overturned the district court. So employers don't need to go out and make changes at this time to their preventive care reimbursement policies or coverage. But the US Supreme Court, if they side with the district court and determine that USPSTF was not properly appointed, employers at that time may need to revisit their preventive care coverage because they may want to or need to impose cost sharing requirements. And back in April was some of the last activity in this lawsuit, and the US Supreme Court heard oral argument on this matter. The ACA pay or play penalty is also the focus of certain lawsuits that are out there. And in this Falk versus US Department of HHS, a court ultimately held that these IRS letters I-226J did not serve as proper certification to an employer that would allow the IRS to impose an ACA pay or play penalty on that employer. This case was limited to this specific employer. The court ultimately ordered the IRS to issue a refund to Falk in the amount of the pay or play penalty. But this does challenge essentially the process of the imposition of these ACA pay or play penalties. Notably, this does not challenge the overall legality of the pay or play penalty. It just provides a potential argument against the process that the government is using to impose these penalties. So excessive fees in breaches of fiduciary duty, these have been common lawsuits against retirement plan fiduciaries and retirement plan sponsors. But now there's a new wave of legislation bringing similar lawsuits against health plan and health plan fiduciaries, alleging excessive fees and failure to monitor service providers. And one of the notable cases on this front is Lewandowski versus Johnson & Johnson. And in this case, the plaintiffs allege that J&J's health plan paid its pharmacy benefit manager millions of dollars for prescription drugs that could have been purchased for much less. And this case has a notable statement in the complaint filed by the plaintiffs, which pointed out that there was a prescription for a multiple sclerosis drug that purchased at a pharmacy without a prescription only cost $40 to $77. But when covered under Johnson & Johnson's program and through the negotiated rates that were set by the pharmacy benefit manager in particular, that same drug cost $2,239.69. In the complaint, the plaintiffs wrote, "This is not a typo. That is how much the markup was for these prescription drugs." Ultimately, the court did not end up siding with the plaintiffs in this case. The court determined that the plaintiffs did not have standing to be able to bring a successful claim in this lawsuit. The plaintiff also alleged issues related to a spread pricing model that the PBM also used to extract profits from the health plan. And the plaintiffs also alleged that the employer itself failed to just properly monitor the third parties in PBMs in a manner that was adverse to the best interests of the plan participants, to the extent that it would be a breach of fiduciary duty of that plan sponsor of an ERISA plan. So why was the case dismissed for a lack of standing? It was because the court ultimately determined that the alleged injury, so higher premiums, deductibles, and co-insurance related to these inflated prescription drug costs, was merely speculative and hypothetical. The plaintiffs did not provide enough evidence to be able to survive dismissal, that these increased drug costs had adversely affected them. Now, this court decision doesn't end the issue for all plaintiffs everywhere. In fact, many plaintiffs may view this dismissal as a guide for how to successfully bring a future claim in the future. So can a plaintiff compare prescription drug prices among different employers' plans, or compare the cost sharing amounts among different plans? That's a possibility for bringing more evidence to the table to show that these inflated prescription drug costs had specifically adversely affected participants in those plans. Knudsen v. MetLife Group is also a case centered around pharmacy benefit managers, and specifically prescription drug rebates that were provided to an employer. And in this case, the employer received rebates related to prescription drugs from either the manufacturer or passed through from the pharmacy benefit manager on behalf of that manufacturer. And in this case, the employer ended up keeping those rebates and did not use them necessarily for the benefit of plan participants. And the Third Circuit decided that that was okay for that employer of a self-funded group health plan to keep those prescription drug rebates. The plaintiffs specifically failed to allege a concrete financial injury to the plaintiffs as participants, because they couldn't show how their own out-of-pocket costs increased, or by how much, as a result of the employer keeping those rebates. Another wave of litigation that is new, that employers need to watch out for, are both the DOL and plaintiffs throughout the country are focused on health plan premium surcharges based on tobacco use. So if you're an employer out there that has a wellness incentive or a wellness surcharge related to tobacco use, you may want to revisit your program and just dot all the I's and cross all the T's to make sure that that wellness incentive is compliant with guidance that has existed for a while out there related to outcome-based wellness programs. And specifically, employers need to provide reasonable alternative standards if employees are unable to meet the standard of quitting smoking, for example. Oftentimes that reasonable alternative standard is taking a smoking cessation class. And also, employers need to ensure that they are disclosing these reasonable alternative standards to their employees in a way that's documented and in a way that makes employees aware of how to avoid these surcharges and penalties. So the wave of litigation out there from both the DOL and the plaintiff's bar is focused on, at this time, low-hanging fruit. So employers that have either provided no alternative standard at all, or just failed to provide appropriate notifications to employees that they can avoid these surcharges, and how to do that. So there's a whole slew of cases out there. So if you're an employer that has these surcharges in place, the important takeaway from this slide in particular is that this is just a new wave of litigation, and plaintiffs are looking for class action lawsuits out there and looking for employers essentially to sue, especially if the employer is failing to meet some of the simpler requirements of those outcome-based wellness programs. This case, Melberg versus Compass Group, this is the first of over 30 different court cases that I'm aware of right now out there about these surcharges, tobacco use surcharges. This is the first case where the defendants have made it past. I'm sorry, where the plaintiffs have made it past the defendant's motion to dismiss, meaning that the plaintiffs have established that they have standing to challenge the premium surcharges. And they've also plausibly alleged that the surcharges have violated ERISA ERISA's fiduciary rules. This case in particular involved an employer failing to provide a full incentive payment to employees for an entire year if that employee satisfied the reasonable alternative standard later in a particular year. So essentially there was a prorated reward for certain employees. And the plaintiff's argument, which survived a motion to dismiss, is that the full reward needs to be available for the entire year. So we'll have to see if, if that's the case. But for employers out there who want to, heed the warning here, you may want to make an incentive or an avoidance of a surcharge available, the full amount available if an employee meets an alternative standard. So the last case I'll touch on relates to GLP-1 medications, weight loss medications, which are definitely a trending topic in the health and welfare benefit world, especially because these GLP-1 drugs are becoming popular, and because the costs of these of covering these drugs continues to go up. According to some articles, about 55% of employer group health plans are currently providing coverage for such drugs. And there is at least one court case out there that addressed whether and to what extent an employer is engaged in potential disability discrimination if it declines to provide coverage under the employer's group health plan for semaglutide drugs solely to treat obesity. So in the one court case out there on this issue, that specific court held that obesity alone is not a disability under the ACA. So declining to provide coverage of a GLP-1 drug solely to treat obesity is not discrimination. You would want to discriminate or distinguish that from perhaps a group health plan declining to provide a GLP-1 coverage of a GLP-1 drug solely to treat diabetes, for example, which would be considered a disability under the ADA. Moving into our last topic, a regulatory update. So a stated goal of the Trump administration, and as evidenced by its executive orders, is to increase the transparency of healthcare prices. And by increasing the transparency of healthcare prices, the ultimate goal here is hopefully by providing increased visibility into the high costs of healthcare. Perhaps employers will have more leverage to be able to negotiate or bring these healthcare costs down, because they'll have a better sense of what those costs are. So the administration has ordered the Departments of Treasury, Labor, and HHS to issue regulatory guidance requiring the disclosure of actual prices for certain healthcare costs in a standardized and easily comparable format, and also to update its enforcement policies to ensure that employers are complying with these transparency requirements. It's important to note that these executive orders on their own do not necessitate immediate action by employers. Rather, these orders are directed at the executive branch, so the departments listed here, Treasury, Labor, and HHS. Once those executive branch agencies issue their own regulations and guidance, at that time, employers will need to dig into that guidance and perhaps make any changes necessary, or provide any reporting that is necessary to comply with these new requirements. So gender affirming care is a popular topic in the news right now. There's an executive order aimed at restricting gender affirming medical care for individuals under the age of 19. That EO came out with a federal funding freeze, which was significant enough to cause a lot of medical providers throughout the country to pause these treatments. And again, for employer provided group health plans in particular, what they need to do with respect to gender affirming care will depend on the regulatory guidance that comes out from the Departments of Labor and HHS related essentially to gender affirming care, whether it needs to be covered, whether it doesn't, when is it considered to be discriminatory. All of those issues are still to be continued at this time. But the Trump administration has this as a major focus. If you happen to be a federal governmental employee or federal governmental employer, there is an executive order that will impact your health plan immediately, and that is an executive order that requires the recognition of only 2 biological sexes when enforcing and interpreting federal law. So if your health plan happens to acknowledge non-binary sexes, that may need to be a provision that needs to be revisited depending on all the regulatory guidance that is set to come out with respect to gender affirming care. There's also, I'll just briefly touch on this, an executive order calling for policy recommendations to reduce the costs associated with in vitro fertilization and to eliminate unnecessary regulatory barriers to increase essentially access to IVF. As always, the DOL has released updated ERISA civil monetary penalty amounts for 2025. The penalty amounts across the board are increasing for failures to file a Form 5500, for example. So if you're an employer who has 100 or more participants in a health and welfare benefit that is subject to ERISA, you'll want to be sure that you are timely filing these Forms 5500 for those benefits. And the penalties are increasing for summary of benefit and coverage distributions as well. So the Department of Health and Human Services and the Office of Civil Rights is still active out there, and still serious about finding and enforcing HIPAA violations. And the newest wave of settlements have all, for the most part, been related to ransomware attacks against employers, medical providers, and employers sponsoring group health plans, essentially where protected health information on an employer's computer systems um, has been the target of a ransomware attack, which, for example, would lock up access to health information until an employer pays a set fee to the bad actor to get that information released. And even so, um, there's no guarantee that that information hasn't already been sold to other bad actors, um, or breached in the terms of HIPAA. So these penalties are very significant. The HHS may launch an investigation in response to a participant complaint, for example. So here on the slide, there was a complaint that two former employees were still able to access a hospital's systems after their employment had ended. That is a breach of PHI under HIPAA. If you have an employee that leaves employment and you don't shut off their access in their credentials, you could be opening yourself up to a penalty from HHS and OCR, and more importantly, putting the health information of your employees at risk of being accessed by not just the former employees, but by any bad actors out there who may be willing to pay for that information. So just a few best practices for health plans to wrap up the presentation today. So depending on an employer's risk tolerance, an employer may want to create a welfare plan fiduciary committee and thoroughly document that committee's meetings with respect to its health and welfare plans. If the employer is concerned about breaching its fiduciary duties related to its health and welfare plans, especially since lawsuits now are not just focused on retirement plans, they're coming into the health and welfare space. It's also important to request requests for proposals for service providers in order for employers to properly evaluate whether the service provider's fees are considered reasonable. And also to identify any potential conflicts of interest that may be lurking that the employer was not aware of. Employers need to monitor their service providers and ensure that the employer is aware of what its plans claim procedures are and eligibility requirements are, because ERISA requires plan sponsors to follow the terms of their plan documents. There is insurance available, fiduciary liability insurance, which employers may consider depending on their risk tolerance again. So some benefits of such a fiduciary committee: it can remove the board of directors, officers, and owners of a company from potentially embarrassing depositions and lawsuits. It can provide the board or owners with reports necessary for that group of management to be able to satisfy their duty to monitor service providers. Ideally, you want to put individuals knowledgeable about the health plan on such a committee. You want to keep an eye out for any conflicts of interest. And of course, document processes and decisions, including meetings, just to ensure that you have documentation of what the committee is doing, why decisions are being made, and why that employer's health plans are in compliance with any regulations out there. So with that, I am not seeing any questions in the chat here that came through during the presentation. So at this time, I will end the meeting, and I encourage everyone to join us for our next meeting in August, and as well as our Ask a Benefits Attorney meeting in December. And thank you everyone for attending today.